Okay, so I think we'll start now and people can join as we move along. So thank you all for coming back. Welcome back to the conference, Digital Governance in the Times of COVID-19. To those of you who have not been here before, my name is Ayelet Sela, and on behalf of the Bar-Ilan University Faculty of Law and the Jean Monnet Center of Excellence on Digital Governance, I am delighted to welcome you to our final conference event. And this is a keynote speech by Professor Richard Susskind on the future of courts. Now, I think to anyone interested on the impact of technology on the legal profession and on legal work as a whole, Professor Richard Susskind likely needs no introduction. He's a longtime visionary of the transformational impact of technology on justice systems, and in particular on courts, our topic of interest today, and legal services and access to justice. Richard is a very prolific author. He wrote multiple books on these issues, and he's also a very busy policy advisor on this matter, including to the Lord Chief Justice in England and Wales. And as you will soon all see for yourself, an inspirational speaker on these issues, as could be attested also by the many participants who were attracted to this talk. Now, I think that before the COVID-19 pandemic stormed into everyone's lives, and before courts world over began to incorporate remote hearings and other types of technologies into their proceedings, not anyone or not everyone could have envisioned, like Richard, what the impact of technology could be on courts. And in late 2019, before the pandemic stormed into our lives, he published Online Courts and the Future of Justice. And this book, much like Richard's earlier writing, turned out to be even more timely than, I think in this case, even he could have expected. And today he's going to share with us some of his thoughts about the way that technology can not only be incorporated in courts, but also transform the work of courts and introduce new pathways for increasing access to justice. So Richard, it's really a great personal pleasure for me to welcome you to our event. And I do hope that next time we can host you at Bar-Ilan University in person. And just before we begin, I want to invite our audience, which includes a very diverse group of ODR scholars and practitioners, court administrators, judges, policymakers, technologists, probably many more. Please, you're all welcome to ask questions using the question and answer, the Q&A function at the bottom of the screen. And we're happy to hear your comments or any other suggestions in the chat function. And I'll do my best to collect these and present them at the end of the talk to Professor Saskind. So without further ado, Professor Richard Saskind on the future of courts.
Thank you very much. I too wish we were together physically. I love coming to Israel, and hopefully at your next event, we can be there, or I can be there in person. The pleasure's mine. Thank you so much for inviting me to be involved. In many ways, what I wanted to do over the next 40 minutes in my presentation is touch on a number of the subjects that you have already covered in the last couple of days and give you my own personal take on them and pull them together as one coherent picture of where I think our court systems are going. And I want to talk under 8 headings, just summarize what for me is the problem we face globally in administering our courts, then suggest the mindset I think we need to have in thinking about the future of court service. And after that, reflect on the impact of COVID-19. Briefly, then I'll talk a little bit about how technology is advancing, say something about AI, because I wrote my PhD in AI and law in the 80s, and in many ways this has been my lifelong interest, and it is relevant. And then I'll answer the question about the future of courts. So it's quite a long run-up. After that, say a little bit about justice, and it might surprise you that I want to conclude on the subject of neurosurgery. So what's the problem we're trying to face? The problem, I think, is straightforward enough at one level, that around the world, because of this terrible virus, many hearing rooms are closed. And so people are unable to conduct cases in the normal way. And as a consequence, also, large backlogs are building up. But actually, the problems are not new, the problems of inaccess to justice, because even in our most advanced legal systems around the world, if we're really honest with ourselves, if you take, for example, civil disputes, generally they cost too much, they take too long, the process is excessively combative. It's also unintelligible unless you're a lawyer, and I believe surely increasingly out of step in a digital society. So although COVID has brought into focus some of the challenges facing our court system, the access to justice problem very clearly predates COVID. But we also have the problem, the enduring problem of the unlevel playing field, the inequality of arms that often characterizes disputes where one party is wealthy and well lawyered and the other party is less well off and acting for themselves. And in some court systems too, we're seeing some staggering backlogs. 80 million cases in the backlog in Brazil, 30 million in India. But for me, the most telling, the most damning, the most worrying statistic of all comes from OECD, whose research suggests that only 46% of human beings live under protection of the law. Less than half of our planet have reasonable access to courts and to legal services. And for years, of course, we've heard the answer is to throw more public funding, to throw more lawyers at the problem. But in truth, if the system is inefficient, if the system is disproportionate, it's inefficient and disproportionate no matter who is paying. And it's not at all obvious to me that there's enough lawyers to go around to solve the scale of problem we're discussing today. So I think we need a new mindset. And the question I ask in my book, and I've been asking for, well, since the 90s, in fact, is this: is court a service or a place? Do we really need physically to congregate together to resolve all our differences? Or might in a digital society there be other ways that we can pursue and resolve legal problems? And that's the main challenge I have been putting to the justice system, to court systems around the world. And to highlight the point, I often tell the story of Black & Decker, one of the world's leading manufacturers of power tools, who when they recruit their new executives, they show this slide and they say, this is what we sell, isn't it? And they all say, of course, that's what we sell. The trainers say with some satisfaction, that's not really what we sell, because that's not really what our customers want. This, they say, showing a slide of a hole neatly drilled in a piece of wood, this is what our customers really want. And it's your job to find ever more creative, imaginative, competitive ways of giving our customers what they want. And I think it's a great lesson here for everyone thinking about the future of courts, because isn't it true in so many discussions amongst lawyers and judges and policymakers that we tend to be a power drill mentality? We're tending to think, what do we do today and how can we make it a bit quicker, cheaper, better, lighter, rather than thinking, what's the fundamental value we bring to those we serve? What's the hole in the wall in the world of court service? And we haven't satisfactorily answered that question, but I'm asking you to distinguish between how we deliver court service today from the outcomes that court service should deliver. And it's these outcomes, I believe, that is the preoccupation of court users. And there's a related mindset issue here about automation and innovation. Technology, the first 60 years of technology in the court and legal world has been automation. It's been devoted to grafting technology onto existing working practices, systematizing, streamlining, optimizing the way we work, rather than using technology to innovate, using technology to allow us to do things that aren't possible with technology, without technology, doing things, therefore, that would be entirely new. And there's a fundamental division here. I think we need to move away from thinking that the role of technology is to streamline our current courts, to offer, if I can put it this way, mess for less. I think the movement has to be towards how can we use technology to meet access to justice problems in new and much improved, and indeed perhaps radical ways. So that's the two mindset issues. Think of the hole in the wall and move towards innovation. What about COVID-19? Well, courts in March 2019, rather 2020, around the world closed. And we had to think of different ways of delivering court service. Generically, I call them remote courts. We have set up a website called Remote Courts Worldwide, www.remotecourts.org. And there we've gathered news and views and opinions and feedback from now at about 120 jurisdictions in how they've moved from physical courtrooms to forms of remote hearing. And frankly, this was simply unimaginable just a year ago, that there would be this wholesale acceptance of remote alternatives to physical hearings. We've seen three types of remote hearing. And we've all got different terminology here. So I certainly advise in England, we should call them remote hearing for a variety of reasons, with 3 subtypes: the audio hearing, which is essentially a hearing by telephone conference call; the video hearing, using much like the technology we're using today, some kind of, people often call them virtual hearings. I prefer video hearings. And then the paper hearing, where there's not really a hearing at all, but arguments and evidence are submitted electronically. There's some kind of exchange of messages and discussion online between the parties and the judge delivers the determination in similar electronic form. And I want to talk about that later. But the reality is, during the COVID period, the dominant technology has been the video hearing. And I've got 6 observations to make about that. The first is they've worked fairly well. Don't work in all cases, but by and large, they have worked far more impressively and have delivered a level of service far higher than most lawyers and judges would have said perhaps a year ago. So video hearings work pretty well. And remember, we're still at the early days of video hearings. The current hearings are the worst that are going to be from now on. We're getting better at understanding the technical challenges, the operational challenges, and so forth. The second observation is, despite the common claim really that judges and lawyers are very conservative and can never change, we've actually seen when the platform was burning, judges and lawyers actually adapted very quickly and very flexibly, introducing new working practices, protocols, using technologies they've never used before. So I don't think it's fair to say, as many people say, that judges and lawyers simply cannot change. We've seen they can. A third observation is that we've seen many minds have been opened and some minds have been changed through this period. Many minds that just a year ago would have denied any kind of remote alternative to physical court hearing, they've now seen that there are other ways that we can deliver court service. And there's some quite very, very forceful proponents now, supporters of alternatives, remote alternatives to physical hearing. So we're at a time where I think we're poised, if we can use the shift in mindset as a springboard, we're poised, I think, well to introduce other changes, technological changes. That said, I still believe most lawyers, even those who approve of video hearings, are still of an automation mindset. We saw this very clearly at a big conference in online conference that Harvard organized. My quotation there is from a poet called William Blake, mind forged manacles. We just cannot help but think. And I believe what most people think is the role of the remote hearing, you drop the traditional hearing into Zoom and away you go. And that's classic automation. That's simply what you try to do with technology, is to enable the old ways of working, but in a slightly different way. So I think lawyers are saying things like, you can't cross-examine in a video hearing. There's some disagreement about that, but I think a different mindset's required, and that is, what are we trying to achieve through cross-examination? And are there any kinds of tools or techniques that video offers us that would allow us to deliver the outcomes of cross-examination? Simply dropping our current processes and practices into Zoom is often not going to deliver the equivalent level of service. We need to be imaginative, like doctors are. And in Israel, for example, an app developed that you can move your iPhone around your chest, and remotely doctors can listen to your heart and so forth. You need that kind of innovation in the face of, for example, doctors saying, I can't see a patient unless it's face-to-face. So we have to think imaginatively about how we might adapt video hearings and use new processes, new technologies to enable us to achieve the old goals. I should also say, I think there's been a polarizing effect here. Although I'm quite optimistic that some people's minds have changed, there really are in the legal and judicial communities 2 camps. Those who are, I say, hankering and hankering after the old ways and hunkering down until the storm passes and want to walk straight back into traditional physical hearings. And those, on the other hand, who say post-COVID, we shouldn't go back. We've got to industrialize what's gone well. So quite polarized views in the legal world, which will be hard to work through. And finally, there's a common trope that COVID has accelerated technological change. Of course, it has to some extent, but it's actually also decelerated some technological change. It's accelerated remote working. It's accelerated video hearings and so forth. But if you think about it, a lot of people say the new future has arrived. I don't believe actually that home working is a full transformation in the delivery of court service. It's just changing the places people are sitting, frankly. Dropping hearings into Zoom is not a shift in paradigm, as the commentators want us to say. The people, the rules, the processes, and the problems are much the same. We're just communicating electronically. But at the same time, the more radical technologies, like artificial intelligence, more of which in a second, actually there's been less interest, understandably, during this period. We've been trying to keep our systems up and running. So we've accelerated the technologies that enable us to communicate, cooperate, collaborate more effectively online. And I think we've decelerated a lot of the technologies that would be more fundamentally transformational. We'll get back there, but we just shouldn't think that all technologies have been accelerated through COVID. I believe COVID's like a huge unscheduled experiment. We've got to gather data about what works well and what hasn't worked well. And I believe we've got to industrialize, as I say, what's gone well. And we have to return to physical courtrooms for hearings and case types that aren't well delivered through a video service. But we have to do that in an evidence-based way. But as I also say, I think we should look upon this as a springboard. The new orthodoxy, of which I think there's a hint now, is we've got lawyers who would steadfastly say you cannot hear a case other than in one another's physical presence, to saying now there is only one alternative to physical presence, and that's the video hearing. I disagree with this fundamentally. I think we need now to go back to the drawing board and think more strategically about how technology can help us change court service. Just a little bit of the technology, because much has been said over the last couple of days, but my two major observations about the trajectory we're on here are as follows. That first of all, we see our machines are becoming increasingly capable. They're taking on more and more tasks, many of which we historically thought could only be taken on by human beings. Not a day passes we don't hear of news of some new system or app or technology or breakthrough. That's the era we're living in, an era of greater technological progress than humanity has ever witnessed. And the second observation is there's no apparent finishing line. No one in Silicon Valley, or indeed Israel, or South Korea or China is saying, job done, let's call a halt with technology, or plateau for a while. Quite the reverse, the pace of change is accelerating. So simply to think that video technology, which frankly, the kind of systems we're seeing in use today were demonstrated to me with a Supreme Court judge in the 90s in IBM's labs. To think that that technology is the end game is grotesquely to misunderstand that we're still at the foothills. So let's say a little about AI. For me, AI and law started in 1970 with a wonderful paper by two Stanford guys. It's in the Stanford Law Review, some speculation about artificial intelligence and legal reasoning. And then 7 years later, Thorne McCarthy, then I think at Rutgers, produced this fairly definitive paper of more advanced technologies that might be used than Buchanan and Hedrick envisaged. And thus the field began in the 70s. And that article, as I say, was in Harvard Law Review. I came into the fray in 81, whereas an undergraduate, left-hand side on your screen, wrote a dissertation called Computers in the Judicial Process. So little work had been done in that area that I was impelled. I thought it was just so exciting stuff. I thought I want to do more in this. I wrote my PhD in Oxford on AI and law from 83 to 86. And here's my high-level observation about this, cutting through so much, I'm afraid, of the nonsense that's spoken about AI and law. I think most of the short-term predictions about AI law hugely overstate its impact. However, and actually more importantly, I think most of the long-term predictions hugely understate its impact. Will AI transform court and legal service over the next couple of years? Of course not. By 2030, yes, I think we'll see AI making considerable inroads into the way that courts and legal services are delivered, which I think defines the challenge for all of us who are here today. The 20s will be the era, in my view, and this is my 41st year working in this. The 20s will be the era when AI has a considerable impact on the legal world. A little bit of time travel that might help. I was involved in the first wave of AI. In fact, I think I'm right in claiming that I co-developed the world's first commercial AI system for lawyers between 86 and 88. I collaborated with a man called Philip Capper, who was the dean of the law school in Oxford. And he came to me in 86. He'd been one of my examiners. He came to me in 86 with this extract from a piece of legislation. Section 2 of this act shall not apply to an action to which this section applies. Now, English is my first language, and I don't understand what this means, but it was characteristic of a remarkable new piece of legislation which fundamentally changed the law of limitation, fundamentally changed the answer to the question, when can I no longer raise an action because too much time has elapsed? He'd written a book on this subject and no one was understanding it, very complex stuff. And he said, why don't we use the tools you developed in your doctorate to develop a system that can answer that question? An interactive system asks a series of questions, and out will come the date on which you can no longer raise an action, together with a line of reasoning. We call that transparency, explaining the rules of law and the premises, the factual premises that were relied upon. We developed that system. This was the front screen. As I always say, in 1988, this was regarded as cool. This was in an era when floppy disks genuinely were floppy. We loaded the system in 2 5.25-inch floppy disks. Big thing to notice was how we did AI in the 80s. Essentially, there were decision trees, huge flow charts, and you manually crafted these. I was the knowledge engineer. I mined the jewels from Philip's head. We represented his interpretation of the legislation, of the case law and good practice. There were more than 2 million paths through this decision tree we crafted, really complicated. And in the end, this was a system that Philip to this day will say was better than him and therefore better than any human being. Reduced research time from hours to minutes and never had an off day or a hangover or a Friday afternoon syndrome. And so pretty early on, let's face it, this is 33 years ago, we developed a system that could outperform a law in quite a narrow, but yet nonetheless significant area of law. Took an age to develop the system, so very costly to develop. But there were 3 things we didn't anticipate at that time: the web, brute force computing, and machine learning. The web, wow. If you were, as I was in the early 90s, about 30, you couldn't believe the web. Suddenly there was a way of no longer, as I'd been for a decade, being a little isolated island in my own wee PC with no links to anyone else. Suddenly I could roam around the world and look at documents and materials and receive service from others. And similarly, I could put materials out there. The whole thing was just honestly completely mind-boggling. And almost all of us working on AI and law left AI and law to work on the web and law because it's just more immediate, more practical, more commercial as well. So that was one, in my view, why we had an AI winter in law, because it was more exciting things to do. Then 97, we're all stunned by Garry Kasparov being beaten by the world, being beaten by Deep Blue, the system developed by IBM, Kasparov, the world chess champion. And we thought that wasn't possible in the 80s because we thought these machines would never have the processing power, because that's how we looked at it. You had a huge search space, and it was about machines searching through huge sets of permutations to find some kind of optimized move on each occasion. And here was a system in 97 that could explore more than 330 million possible moves in 1 second. Mind-blowing. A good chess player, 100 moves in his or her mind at one moment in time. So this got us all thinking the world of AI has moved on. But the real change in AI, of course, as you've been discussing, was away from systems that were programmed, systems where you explicitly wrote the routines, represented the knowledge, from systems that learn from huge amounts of data. And that's strangely enough, and I didn't see the significance of it, I did my own little machine learning project in the late 80s. I just didn't think it was workable. It just shows how limited a view one can have. That great technology was staring me in the face. And I was working with a leading AI scientist, and I just didn't see it at the time. In any event, we've moved from systems that are programmed to systems that are learned. And frankly, I think people still don't understand this. People still say things like machines can't do things that weren't in the contemplation of the programmers, or garbage in and garbage out, which I understand in the data context can have meaning, but it's not with their meaning. These systems, as you'll have been discussing, can discern patterns, can discern, identify correlations, trends in huge amounts of data, can on the basis of that make remarkable predictions, and in consequence essentially be offering advice and guidance in a way that is way beyond the very explicit routines that we put together. That's why in medicine you've got systems. Here's one that can outperform dermatologists in identifying whether or not a mole is a malignant melanoma. It knows nothing about histopathology or dermatology. There's 127,000 past images of lesions together with the results of the pathology. And frankly, this is actually just computational statistics. It's complicated, but the system can draw on this huge database of experience, which after all, in a way, is what a doctor does. But no doctor has got that body of experience under their belt. And similarly, you'll have heard of Lex Machina as one of a number of systems, but a very early one that can predict the outcome of decisions. Lex Machina, claims have been made that it can predict the outcome of patent disputes in the United States more accurately than human lawyers. It doesn't matter if that's true or not today. If you take this kind of technology and you work alongside other technologies, it's just a matter of time before these systems can work at a very high level. And remember, incidentally, again, that this system knows nothing about the law. It's actually got a 100,000 or 200,000 past records of cases, who the judge was, who the lawyer was, who the law firm was, the nature of the claim, the size of the claim. Turns out, again, if you've got enough objective data, this is a huge challenge for lawyers. A system can predict the outcome of a case more accurately than the legal method. And as I say, even if it's not true today, it's going to be true soon, in my view. Lawyers are horrified. They say this is dangerous. But I always say this: what's the question that every client asks when there's a dispute coming over their horizon? And the question they all ask is, what's our chances of winning? To roll out the legal method is to think of power drills. The hole in the wall is a probability. If computational statistics can demonstrably and more cheaply or more conveniently deliver that probability than the human legal method, the market will default to that. And that in microcosms, the kind of shifts we're seeing. Many lawyers will then say, well, hang on a second. I'm a lawyer. I think, I reason. I'm a bit creative. No machine can ever do that. And therefore, my work is safe. And that's to commit what Daniel Susskind, my son, and I, in our book, The Future of the Professions, call the Ai fallacy. And this is fundamental because I actually think that most AI scientists commit the AI fallacy as well. I even think the distinction between artificial general intelligence and narrow AI is a commission of this fallacy. So the fallacy is this: it's the mistaken assumption that the only way to develop systems that perform tasks at the level of experts or higher is to replicate the thinking of processes of human specialists. It's still to think what we're doing is first generation AI, that we're programming and copying human beings. But this is really not how these machines work. These machines are not working in the same way as I do. They have remarkable processing power, even more remarkable collections of data and clever algorithms underpinning them. That's their distinctive characteristics. And this conception that so many people have in the debates about the future of lawyers, and there's always some kind of cartoon of a robot there. This was a robot, this is a cartoon the Economist drew for our book, but there's always a robot sitting in the lawyer's desk as some kind of threat. And that's to commit the AI fallacy. It's to think that the machine that will replace lawyers will in some sense look like lawyers. But frankly, you don't need nostrils, you don't need elbows, you don't need shoulders to generate a legal document, for example. That's the way we do it today. The big thing is that it's not that the way we're going to replace human lawyers, some of the work of lawyers, is by putting a robot in their seat. That's as daft as thinking the way we're going to replace conventional cars and move to autonomous vehicle is by putting robots in conventional cars. That is committing the AI fallacy. Robots are not sitting in cars. You actually don't need steering wheels in principle. You certainly don't need arms and legs and little pedals that you move in your feet. These systems are driven by data in ways that I'm sure you've discussed or alluded to. But the AI fallacy is absolutely fundamental because it restricts people's views of how great the impact of AI will be on our lives. Because most people, and the economists can really be challenged here, all they talk about is task substitution. They say, what are all the tasks a human being does in a particular job? And what of these tasks could be done conceivably by a machine? The stuff that's not done by the machine, 45% lawyer. I think one of the research says, okay, so half our lawyers are safe. It's in so many ways nonsensical. But the point is, and I'll get back to this in a second, if, for example, you think of oral advocacy, the fallacy is to think that, as many people do, a machine can never stand up and make a presentation in courtroom, and therefore oral advocates are safe. But what if we move to what I'm going to be talking about in a second, to online asynchronous hearings where there's no advocacy at all? What if that becomes the dominant way of working? The argument that robots can't stand up in court just becomes irrelevant. And this is the big change we will see. And this is genuine innovation. We've got not to think about using AI to automate. We've got to think about how we use technology to allow us to deliver the outcomes people want, but in entirely different ways. But even on the point of creativity, fascinates me where people say machines can never be creative or systems can't. this is an old story, of course. AlphaGo, you'll be familiar with it, the system that beat the world Go champion 4-1, where AI scientists said it would be a decade before a system could ever play a good game of Go. But the most interesting thing in that game was the second game in the 37th move. The machine moved the piece. The commentators thought it was a mistake. A Go champion later described the move as beautiful and said it brought a tear to his eye. In a human being, we would have called that move creative. We might have called it imaginative, innovative, maybe even genius, but it was none of these things. That's to anthropomorphize. That's to impose human interpretations of what these machines are doing. This was just lots of data processing, clever algorithms. And we use terms like a machine can't be creative. And by definition, that's true because creativity is a human attribute. The more interesting question is, can the creative output of a human being be generated by a machine working in a different way? And we're seeing this already in paintings and literature and music. The machines are generating. They're not copying us, they're using data. So that's the era we're in, folks, of increasingly capable, non-thinking machines. I call this the second wave of AI. So that brings me, that's my run-up, folks, to the future. We've got this grotesque difficulty of problem of access to justice. We live at a time where technology is moving ahead at a remarkable rate. We've seen that lawyers can change. We've seen there's a possibility of working differently. So what might the future hold? Well, this is what I wrote about. And you were kind, of course, I didn't predict and would never have wanted my book to sell well because of COVID. But I did write a book in 2009 about online courts. It wasn't really about video courts. There's quite a lot about video courts in it. But that wasn't my point. And I'll explain to you what my vision of the courts in the future is. But the premise of this is, isn't it remarkable? More people now have access to the internet, 59%, than access to justice, 46%. Now, I find this bizarre. This is something I predicted in 2000 and said within 10 years, but actually in a very small number of years, more people had access to the internet than access to justice. This is something of which we should, as lawyers, be, in my view, collectively ashamed. So what does the road ahead look like? What does the future look like? Well, I think there's 5 fundamental building blocks to the future of courts. I call them asynchronous hearings, extended court services, front ends, AI, dispute avoidance. I've got about 10 minutes to run, so I can only give you a glimpse, but these for me are the building blocks. Asynchronous hearings. I've mentioned what these are already. These are paper hearings. This is the idea not of having a hearing at all, but evidence and arguments are submitted electronically. There's an online discussion, almost like an exchange of messages or exchange of emails amongst the parties and the judges, and the judge delivers the conclusion, the determination in electronic form. This was a vision a number of us came up with in 2014, 2015 for the UK. It really isn't suitable for all sorts of cases, but we thought this is the way of tackling very high volumes of very low value civil cases that actually are clogging up our court systems around the world. You don't need to take a day off work. You can engage with the court at your own convenience. You don't need to be freaked by the procedure and the formality. It's still got gravitas, and the judge, and this is wonderful for the diversity of judge, doesn't need to be a judge who commits to working office hours. The judges too can work at their own convenience. So we thought asynchronous hearings, or what we call online judging, is pretty much a no-brainer. Not for all cases. The big challenge is to find those cases for which it works. However, and far more radically, in my book, I call for extended court service. And the point is this, that in a digital society, it seems to me to be simply intolerable that the best we can do is offering online judging, because around the world, almost no one can afford legal services. And simply having an online judge available to you is really not much help unless you understand your legal position. And so the point here is, surely we need some tools that can help people understand their legal position, understand the legal options available to them, that can help them organize their evidence, that can help them marshal and structure their arguments, that can offer them online tools for negotiation and mediation, not as an alternative to the court system, but baked into the court system. So I said the state should have a responsibility to go way beyond its traditional primary purpose of delivering authoritative binding judgments. The state should surely help people navigate the court system in the crudest of terms, because otherwise it's not really access to justice to say we've got a court that everyone can access. We need to be able to equip people, otherwise they're just entirely disempowered. And I provided an architecture for this, and it's in detail in the book, but there's the best empirical evidence for all of this is the Civil Resolution Tribunal in British Columbia, which both exhibits online judging and a variant of a form of the extended court service I provide. And also we see eBay, it's become trite, but it's nonetheless powerful illustration. Every year, 60 million disputes are settled on eBay, not by humans, lawyers and judges, but by a form of online negotiation and not a form of online adjudication. However, I do accept post-COVID that to be inviting the state to invest more when it's restricting its public legal funding is probably whistling in the wind. And so I do hint in my book, and I've fleshed this out in more detail in this article I wrote for the Harvard online publication, The Practice. I can see a private-public arrangement where you have front ends to the court system that provide this extended court service, that provide people with the tools to help them understand and navigate the court system, and in some way is connected to the court system for enforcement and for the passage of documentation. So in a way, this is a kind of halfway house between private sector ADR and public sector online dispute resolution of the sort I mentioned. I want it to be linked to the court system. I want it to have the teeth, the backing, if I can put it this way, of the coercive powers of the state. And so I believe we'll build front ends to court systems that'll help us alleviate some of the load in the court system. And in the UK, under the auspices of LawTech UK, we've just commissioned a detailed study into how this might work for small and medium-sized businesses in their pursuit of debts. And then there's artificial intelligence. I've spoken what I think it's about. How will this be used in the court? In three ways, I think: to provide online guidance, to provide predictions in support of early resolution, and far more controversially, predictions as determinations. Just a little bit about each. The kind of diagnostics that I think human beings need to help navigate the legal system, to understand the options available to them and their own legal positions, I reckon we still need to use first wave AI. I think we still need to use rule-based systems. It'll be pretty much the kind of work I did in the 80s. And that, if you look at Solution Explorer in British Columbia, is pretty much what's in place. There are more simplified versions. You can have guided pathways, you can have decision trees and so forth. But the Rolls Royce here is the diagnostic rule-based expert system, still remains that. And that's a first generation AI that would be used as part of the extended court or in the front end. The second is these systems like Lex Machina, which can help, I believe, bring about early resolution. If parties can quite quickly identify the likelihood of their case being favorably settled or otherwise, I believe that would be a very useful tool to help them decide whether or not they want to proceed. So I think we'll see these predictive systems within the extended court, and it'll be one piece of guidance people will receive in deciding whether or not to proceed. The third question about predictions and determinations really takes me back to the early 80s when I was asked the question, can computers replace judges? And there's various questions that we might be asking there. Can our current computer systems reason and solve problems and work like human judges? The answer to that is emphatically not. Neuropsychologically, neurophysiologically, we're nowhere near being able to understand what it is that human judges do, still less to model that with a machine. What about a second claim, which is more modest, that what judges really do is provide decisions with reasons? Have we developed any systems that in sufficiently broad areas of law could be put into service to deliver a decision with reasons? I don't think we're anywhere near that yet either. And frankly, as we'll know, and I'm sure others have discussed, one of the shortcomings of the second generation of AI is precisely they can't really provide reasons that we would regard as sufficient reasons for judicial determinations. But there might be a third option here, and I call this as predictions as determinations. And this is the idea, going back to Lex Machina, these suite of facilities that people are developing that predict the outcome of cases. So to put up the thought experiment, I'm not necessarily recommending, I'm just saying think about it. Brazil, 80 million backlog. Imagine we said to people in Brazil, your particular case won't be heard for about 360 years. We just don't have the manpower, the person power to do this. But we have a system based on past decisions of the court that will predict the outcome in your case. You could say to parties, would you regard the prediction made by the system as a binding determination by the court if, say, the degree of confidence by the system is 95% or higher. I'm not saying do this, although there are other countries already onto this, but I'm saying that is a way that we could deal in, say, Brazil with tens of millions of cases, predictions as determinations. I know there are problems with opacity of data. I know there are problems with bias of data. It's all good. Once you move beyond, I live in two worlds. I live in the world of academics, where I myself love it, dancing on pinheads. But when you live in the world of practical politics, the reality is 75 million people are never going to get their cases settled in the normal way. So the best can be the enemy of the good. We have to make sure we move for improvement rather than perfection. The final thing I want to say is that I don't think a court system is doing justice, literally, to those who are under its remit by simply resolving disputes. I think we need to build into our systems procedures that help us contain disputes so they don't escalate. Indeed, procedures that help us avoid disputes in the first place. And I call this putting a fence at the top of the cliff rather than an ambulance at the bottom. And I think we'll use technology as part of extended courts in the future to do precisely that. What about justice, I hear you ask? Judges without courtrooms, justice without lawyers, the whole thing's an affront to all of us, many people say. Well, my background is, I used to teach jurisprudence in Oxford, and so I'm interested in this. It's not I don't think about justice, I think about little else when I'm talking about this. But what I've identified is this phenomenon that people defend and attack online courts in the name of justice. And what's going on here is there's 7 different conceptions of justice at least, I think, in our thinking about justice. And so I say for any court system, we need to deliver 7 forms of justice: substantive justice, the decisions are fair; procedural justice, the process is fair; open justice, the system's transparent; distributive justice, it's accessible to all; proportionate justice, it's appropriately balanced; enforceable justice, it's backed by the state; sustainable justice, sufficiently resourced. I could say I've written a book. I have written a book. You could write a book. I have written a book on all of this. But some people who say, for example, who worry about procedural justice are less worried about distributive justice. Some people are worried often about transparency, but I would say to them, a challenge, maybe a slightly less transparent system that's affordable to all is maybe a good thing. So we've got debates to be had, but let's not do what many practicing lawyers and say that won't be a just system. This is a far more nuanced debate. My own analysis suggests red line representing traditional system, yellow line suggests representing online courts, that in every reasonable, and this is for high volume, low value disputes, that under each heading, actually, these online courts will produce a more just outcome. The message to the skeptics is this: if you're really interested in access to justice, the issue isn't whether or not online courts will replace traditional courts or which of the two are superior. It's whether online courts can take on some of the work that traditional courts do not or cannot, because that's the grave access to justice problem we face. Of course, it's problematic that self-represented litigants struggle with the system. But in many ways, what's far more problematic is that almost everyone is excluded from the system because they can't afford it. Finally, in neurosurgery, just with a minute to run, I was invited to give a talk to 2,000 neurosurgeons in Boston in 2017, and they asked me to be controversial. So I started my presentation by saying patients don't want neurosurgeons. And there was a huge gasp in the audience. I said, patients want health. I said, you're the best answer today to a particular type of health problem, but probably 50 years from now, people will look back and say, it's unbelievable we used to cut bodies open. How incredibly primitive that was. I said, it's wrong to think the future of surgery is better surgery or robotic surgery. You're asking the wrong question if you ask what's the future of surgery. The question you should be asking is how in the future will we solve problems to which surgery is currently our best answer? And the reality is the future is about preventative medicine and non-invasive treatment. So the future is not about better surgery. And similarly, I say to you folks, that the question, what is the future of courts, is the wrong question. This is the question we should be asking. How in the future will we solve problems to which the courts are currently our best answer? Because remember this, people don't actually want courts. People want the outcomes that courts bring. So the challenge for us is to identify these outcomes and use innovative technologies to allow these outcomes to be delivered far more widely and to a higher standard. Now, many people listening in, or certainly many lawyers, when they see this, I simply say that they hope they can hold out to retirement before any of this matters. I look at this image very differently. I think this is a human judge involved in online judging. He's taking inspiration from nature. He's got his laptop on his knees, you can't see it, and he's about to put the finishing touches on an online judgment. Thank you very much, folks.
So thank you, Richard, for a really thought-provoking presentation and some big questions that you've presented and began to answer. And I think this is really opening or paving the way for us for both broad discussions and some concrete questions. And I'd like to start us off with a few comments and then open the floor for some more questions from the audience. We already have a few of them accumulated, and I invite all of you who are interested to present more questions. So my first question has to do with what I think is a theme throughout your presentation, which is the tension between what we think courts provide or the nature of the service that courts provide and what courts actually provide or what people go to courts for. And I think about this not just in the context of online courts, but in courts generally, going back to what Mark Galanter termed as the vanishing trial phenomena and what is actually happening in courts, which is in very rare instances and adjudicatory determination of the merit of the case based on the rights and the laws and the facts presented. And most of the time, what we see is other forms of dispositions, many times of people who simply do not defend their case, but often settlements that are reached between the parties. And much of what we see today in online courts in practice is this attempt to move parties towards consensual settlements, towards resolving their cases in an assisted form by the online courts, with the minority of cases reaching judges as well. And so my question to you, and I think this has to do also with your vision of extended court services and of this idea of how we incorporate front ends in the delivery of justice. And it also has to do with your answers to the question, what does AI do in courts and what can we inspire AI to do in courts today? Should we be thinking of a different standard, not of those 7 elements of justice that you've described, but rather a standard of redress, of how it is that people resolve their problems and acknowledge that for many people, this is what courts provide. This is the service that the court would provide. And if so, how should this standard or how should this practice, the service that is actually being provided by courts, affect our perceptions, our designs, the standards that we develop for evaluating online courts and designing them in the first place? So that is sort of a first overarching theme of the tension between justice as a standard and redress as a standard in the design of future courts.
Do you want me to answer that?
Yeah, sure. You could jump in.
It's a great question, and in many ways, you're saying what's the hole in the wall, and you're saying that maybe these aspects of justice are actually all power drill characteristics. But I think constitutionally, so long as you still have a broad separation of powers and you still have what I call the primary purpose of the court service to deliver these binding determinations, it's quite hard to avoid, I think, conceptions of justice. But I think what you were saying, and you're right to say, this relates more to the extended court. And in some ways, this is partly an empirical question. And I think of the kind of research that Hazel Gen's done on why people actually go to court. And I think we need to find out far more about what it is people are trying to do and what outcomes they're after when they seek redress, as you say. But I don't think it's purely empirical. I mean, people's conceptions of what they are doing when they're resolving a dispute are to some extent constrained by the methods they think are available for resolving the dispute. And it goes back to 2 of my favorite stories. One is about Henry Ford, who, as you know, invented, broadly speaking, the motor vehicle, and was once asked, how did you come up with that idea? Did you ask your customers what they wanted? And he said, if I'd asked my customers what they'd wanted, they'd have asked for faster horses. And so the trouble with a lot of research into the future, first of all, there's no evidence from the future. Secondly, there's something slightly strange about asking people who don't know anything about what's possible what it is they might want in the future. And that's that leads me to the Steve Jobs point, which is that people don't know what they want until we show them. And that's and this is not a knockdown argument for what you're saying, but what I'm saying is we need to do, I think, far more empirical study into what it is people want to do when they find themselves in conflict, what kind of outcomes they're wanting. But we also need, I think, in the context of that work, to be stretching people's imaginations about the ways in which problems might be resolved, because they might not be in people's contemplation. Your big point is right, though, which I expressed, is what we've got to be focusing on is the hole in the wall, not the power drill. So everything you say, I think is very valuable there. I have to say, there's a very interesting question about how long you wait before you go ahead. I don't think that wouldn't stop me trying to introduce online courts around the world. And this is one of the a charity I'm trying to set up to do that, because there are still enough people in this world who are suffering badly from not being able to understand and enforce their entitlements. There's still enough we can do. And we need to do a lot of empirical work as we develop these systems and roll them out. But as I say to everyone just now, our current system is not an evidence-based policy. It's not based on some kind of evidence-based thinking. In fact, we've got very little evidence about our current system around the world. We don't capture enough data. And so our current system is where we happen to be, not really an informed policy-based choice. And if you can see that I and others are presenting at least a hypothesis of a far more accessible system, there'd have to be very strong arguments for not having a go at that. What you've underlined is the importance of being very clear what our objectives are. And in many ways, you're also, I think, mirroring my comment about automation and innovation. Online courts surely just can't be a virtual version of what we already do, perpetuating problems and ignoring others. So great question, thank you.
Oh, great. I'll use my privilege as the moderator to ask just a couple more questions, and then we'll turn to the questions from the audience. One question that I have, which I think will interest a lot of people in our audience, is what do you think about the future of legal education and of professional training for lawyers? What are the kind of skills that the lawyers of the future will need as they go into practice in this new world or that is ahead? I think building also on your work with your son, Daniel, what are kind of the perhaps new professional standards that we need to develop in order to ensure the quality of legal services in this future?
Well, that's also a great question. I just happen to have on me, which I carry with me, my book, Tomorrow's Lawyers. That's in the second edition. The reason I wrote that originally in 2013, I was getting so frustrated, and I remain frustrated by most of our law schools around the world. The fundamental question for me is, what are we training young lawyers to become? And I think we're training young lawyers to become 20th century lawyers rather than 21st century lawyers. We're churning out people who are fit for purpose in the 90s. If I'm even partly right in my predictions about more and more legal tasks being undertaken by machines, and you're already seeing it in document review and litigation, you're seeing it in due diligence work, you're seeing it in document drafting, you're seeing it in legal research, you're seeing it in prediction. Already we're seeing significant inroads, and it's just early days. 10 years from now, huge swathes of work, and this is just task substitution, will be undertaken by machines. And so I think we have to completely rethink how we teach and what we teach. The how we teach, to some extent, has been rethought in part for us during COVID, because we now realize there are other ways of teaching. But what we teach is fundamental. And I think simply focusing on the generation of one-to-one consultative advisors who charge by the hour is just not the way to go forward. If you accept the thesis of increasingly capable machines, it follows logically that there will be over time less for traditional human lawyers to do. So that for me raises the fundamental career question for every young lawyer and every law student. And that is, do you compete with these emerging systems or do you build them? And what I mean by this is this: by competing, you would say something like, really enjoyed your talk, Richard. You're probably overstating it. You don't really know the kind of lawyer I want to be. I'm sure there's going to be lots of legal work, and my parents tell me this is true. There's lots of legal work for the traditional lawyer, and that's the work I want to do. And I say that's competing with these emerging systems, because what you're saying is there is quite a lot I can do that a machine will never do. I think it's a very bold claim. And if you look at any of the work of economists who are trying to anticipate the balance of work between human beings and machines, the slice to the machine is getting bigger, and the slice to the human is getting smaller. So I say, both for the career plans of young lawyers and for the business strategies of law firms, it's pretty bold, and for law schools, to say that the world that we want to occupy is the diminishing world of people who compete with machines. However, and here's the real excitement, I think the next generation of lawyers are the people who build the machines that replace our old ways of working. And so tomorrow's lawyers, I have a list of people like legal process analysts, legal risk managers, legal knowledge engineers, legal project managers. I often put up that list and say to lawyers, these are the people who will be developing the systems that will replace our current ways of delivering legal services. And then make the bolder claim, these are tomorrow's lawyers. People say, well, they're not lawyers. I know they're not lawyers in the sense of you went to law school in the 80s to become a lawyer, but surely the people who are developing solutions to clients' legal problems can reasonably be called lawyers. And therefore, this answers your question. We need to extend, if you accept this argument, we need to extend our training, our law schools, well beyond conventional, and I know it's already a basic curriculum, but well beyond conventional legal training, so that we are generating people who can develop document generation systems, who can develop the systems that will replace our old ways of working. So again, a great question, and one, if you ask me what's my biggest worry about all of this, it's that our law schools by and large haven't woken up. And most law professors, it's worse than that. Most law professors do not think that this is an area of legitimate legal study. It doesn't mean it's illegitimate, but it's not part of legal studies. It's not part of the curriculum. It's not something research into which should be recognized as conventional legal scholarship. And I think if we maintain that attitude, our law schools will no longer be fit for purpose, and we'll find alternative means of training the next generation of lawyers. So it's life or death, essentially, for law schools as well. I'm not talking overnight again, but if you look at 2030, I think law schools that fail to heed this will be in grave difficulties.
Thank you. I hope that there are some law school deans in our audience that will hear your...
Unlikely.
There's at least one.
Yeah, well, you see, the trouble with this event, it's not your event, it's trouble. The trouble with these events are you get a kind of self-selecting people who are interested in coming along to listen. And so you have one or two enlightened deans. But for me, the biggest opportunity ever was when I spoke to, I can't remember how I got the platform, but I was given the keynote address, I think it was about 2012, to all the deans of US law schools. And I was rubbing my hands thinking, this is the big one, this is my opportunity. And it just went down like a rat sandwich, as we say over here. And that's why I wrote the book, because I said, I'm not going to get this by convincing current deans. What I need to do is convince the next generation of deans.
I can say, Richard, as the dean of Bar-Ilan Law School, that it's very reassuring for me to hear these words, because we actually kind of work in that direction. We've introduced a course on data science for lawyers in our curriculum, and introduced several other data science topics for students, and also established a data science lab at the faculty. So it's nice to hear that someone thinks that we're in the right direction.
Yeah. Well, mazel tov is what I say.
So I will put aside my third question, which had to do with thinking creatively about the role of judges in this new model of courts. And so we'll leave that for a future discussion, because we have many questions in the chat for the panelists and in the Q&A. So I'll start by a question presented by Clive Walker, and I hope I reframe it correctly, which is, if we move into the world of AI-based decision-making, or in the incorporation of AI decision support systems in courts, what do we do to make sure that these decisions do not embody outcomes that are racist, or that are in some ways reflect racism? And how do we make sure that the judgments about humans, which we wish to be normative judgments, remain such judgments? And can we take statistical predictions to substitute these kinds of decisions?
Well, there's so much there. I just want to stress, I'm really not saying that computers are going to replace judges anytime soon. I was saying that these predictive models might be a pragmatic fix for low-value claims where otherwise people are just, they live with the uncertainty of open-endedness. There's so much we need to think through, and in many ways, what I'm trying to do is start the conversation rather than finish the conversation. On the question of bias, and of course it's a very important one, I do think that very often what people are talking about is the unconscious embedded bias and the extent to which, so it's entirely conceivable in my Brazilian model, for example, there, that yes, the system would predict the outcome of that case, but that actually is perpetuating a whole bundle of biases that haven't been made explicit, but actually on analysis, on algorithmic analysis, we would see. My first observation is our whole common law system is based on past data, and almost certainly and more worryingly perpetuates past bias. So when, and it depends what kind, whether you're civil or a common law system, but if you're in a common law system, I have no doubt that when we do the analysis, as we will, the lines of reasoning, paths on which the law develop, when we look at them, they will be premised on unconscious bias on generations of judges before. What I think is so terribly healthy about the question and about the techniques we're thinking about is we are now developing techniques which help us unearth and identify bias. We're going to develop techniques that help us monitor bias. We're now explicitly talking about bias in a way I've never heard anyone of the common law system talking in the way we talked just now about the opacity of data and the embedded bias. Never heard people talking about how we might systematically look at that. It's obviously noted that it's been dominated by guys like me, white guys in their 50s or 60s. That's been noted. But it's only now, I think, we're really thinking in a nuanced and sophisticated way about how we might analyze that. Secondly, I'm not saying that these systems for the foreseeable future will be deciding hard cases. I think difficult cases involving tricky questions of policy or principle or morality or purpose and so forth will be handled by human beings under ever greater scrutiny in openly just systems. And these decisions that they make in hard cases will then be fed back into the data. So I think implicit also in the question is a little bit that if you just get one body of data just churning out the same decisions, not only is it perpetuating bias, but it can never change. It's somehow ossified. And so I don't have the answer. No one's got the answer to how it is, for example, we can develop these systems so they can offer, I think even the question of how a system can offer, how a machine learning system can explain its line of reasoning, I think is a misunderstand how these systems work, and actually is to commit the Ai fallacy. But how it is that we can have any kind of insight into what's going on when a machine learning system generates a conclusion, and how it is we can eliminate bias. These are the prime concerns of AI science around the world. These are the prime concerns of AI ethicists. I'm not saying the problem's been sorted, but at least we're now recognizing there's a huge difficulty. And I suspect there'll be at least partial solutions to these long before the legal system pervasively uses these technologies.
So we have a couple more questions that are centered around the use of AI in judging. So I think that part of your talk raised a lot of interest. I'll try and
always does.
Yeah, I'll try and connect them together. So I think you've answered Pavel's question as how do we see AI working in more normatively challenging cases, saying that these would not be the type of cases that AI would handle. And I'll tie in together two questions by Dr. Erlich Temeli and Professor Everett Steinhaus. What are the type of weaknesses that you do see in incorporating AI as you do see it now in judging? And do you think, given the current capabilities of AI, that AI could replace judging in those simpler cases, those run-of-the-mill cases? And so the idea here is not just decision support or self-diagnosis, but actual judging.
Yeah, and the reason I said these questions, people always talk about AI. I often don't talk about AI anymore because, in a way, I don't. In the book, I distinguish first and second generation online courts, and first generation online courts are human judges deciding cases asynchronously. The second generation are AI, and I always worry. I'm going to answer the questions, but I always worry that the real excitement of being able, in a fairly short number of years, to offer wildly greater access to justice by asynchronous online judging is often just lost in people's excitement or horror at the idea of AI in law. And the second question I thought I answered really, I just don't, I think it's partly commit the AI fallacy to talk about AI systems taking decisions because that's not how they work. And I think that's anthropomorphizing it. That's thinking that they work and reason like us. I still hold by my observation that these systems technically can't provide decisions with reasons, and to seek to try to develop them so that they can is a remarkably human-centric view of how to approach a particular social challenge, that's say of decision making. And I say again that for me, for the foreseeable future, I can't see AI-based decisions being anything other than predictions as determinations. So I hold to that, and it's partly a technical claim, and it's also just partly it's not philosophical, but it's just I think it's, and I'm not criticizing anyone, I think it's muddled thinking to keep on asking, and I've done it myself, but to keep on asking, can AI make decisions? Because in a way, the answer to that is decision making, I think, is a distinctively human attribute. It's about the saying, can my car make a decision when it decides to turn right? I don't think we're saying that of machine learning systems, because that's a way of characterizing neuropsychological, neurophysiological processes. So we've got to be very careful we're asking the right question. I'm not sure I recall the first question, the first part of the question.
So it was about the weaknesses that you see in AI decision making, but I think that was in a way weaved into your previous.
Well, I think it is. I mean, the two problems are the bias within the systems and the opacity of the systems.
Right. So a question from a different direction, and really taking advantage of your perspective over the years, and now also being involved in the remote court projects and in accompanying these endeavors. Professor Orna Rabinovich-Einey is asking, what are the type of, what kind of mutual learnings do you think can happen now between remote courts and this idea of Zoom hearings and so forth, and what is happening in ODR more broadly? So the more expansive concept of ODR in courts, and are there any now mutual learnings that can inform the development of these two separate tracks?
Well, Orna's an old friend, so it's nice to hear from her, and as I would expect, a great question. Just as a generality, it is possible that remote hearings, video hearings, actually in the long run will divert us away from ODR. And this is my point, that I believe video hearings are a form of automation accelerated by COVID. And when I was saying that some technologies were decelerated, I think a lot of the ODR techniques were put in back burner. People weren't leaning for online semi-autonomous negotiation and mediation systems, the more advanced stuff. People were dropping hearings into video. I think the learnings, though, in practical terms, there's a fascinating thing here about change, because in many ways what I've spent my life trying to do, and I'd say by and large unsuccessfully, is trying to change the way that lawyers and judges behave. And the biggest question is how you can bring about change. And I think what we've learned is that, and I did note this, that judges and lawyers are capable of change, but there has to be some massive reason for them to change. It almost has to be that there is no choice but to change. And I don't know whether or not, when the world, goodness knows, I hope it soon, returns back to relatively normal, people won't just find comfort in the old ways and won't feel impelled to change. So the question is the platform burning? Is the iceberg melting? And the reality is, I think it's incredibly lawyer and judge-oriented question, because it isn't really about lawyers and courts. It's about the 54% of people who are excluded around our world from court systems. And they don't even have a platform to burn. They don't have an iceberg. There's nothing there at all. So it always amazes me when judges say, oh, the platform's not really melting. Your service, I mean, patently, our global justice services are broken because they're just not widely enough accessible. And yet I think, and this is the learning, that unless we have some highly compelling reason to change, I don't think people will move towards the kinds of ODRs at the speed we would want that Orna and others have been working on, and that I heavily support. So I find that really slightly distressing or not even depressing. And a friend of mine who works for the National Health Service said, you only change when you run out of money. And that's the more practical point. I think around the world where court systems post-COVID are finding themselves starved of funds, and that's just a horrible reality. It may well be that it's not the virus that will bring about the change. It'll be the lack of funding to deliver. We'll say the only way we can carry on is if we deliver. But then again, we'll default to video services. So that's one thing. Second thing is leadership. I do think looking across remote courts worldwide and looking at various jurisdictions, where some jurisdictions have hammered on and others haven't, you can see it's due to judicial and political leadership being aligned. So if you really want to bring big change, you need the funding and you need the political and legal leadership aligned and that vision. I think there's technically some great lessons as well, that we could often actually just be, we can be caught out by simple things. It's not trivial things, but simple things like poor internet connections, unfriendly user interface. We have to remember we work a lot often, and I'm the same when we're more in the research side of things. We work in the big ideas, but a very interesting question is what systems land and what systems don't land. And one of the reasons video landed is it was just pretty easy. It was plug and play. And so I think when we're thinking of ODR, I've got to make it plug and play. The most successful single technology amongst lawyers that I've ever seen was the BlackBerry. Because the BlackBerry, you said, here's a little device. It's really obvious what it does. You don't need to change anything you do to get benefit from this. This is all plus. There's none of this, it'll take a while to learn it. You'll learn it in about a minute, and it just brings you new benefit. And people took it running. You're running to the courtroom, you take your, metaphorically, you just pick up your BlackBerry. And so we need to think pragmatically as well about how we can make this easy to introduce. Many other answers.
Yeah, it's tempting to end with this answer, but we have so many other questions, so I'll pick just one more, okay. And we'll try to make it brief. So Dr. Itai Versimanto.
A big fan.
Can ask via video, I think.
Oh, good.
Oh, thank you very much. So first of all, thank you for really an inspiring talk and very compelling and convincing. So my questions will be more being an devil's advocate because I was very much convinced. So two brief questions.
Itai, we can't hear you very well.
You can't hear me?
Oh, good. Now I can hear you.
Now we can.
Okay. So yes, first I said thank you very much for a very compelling statement, and I was very much convinced. But my questions would be being the devil advocate. Okay.
Please
so
do.
the first is, what about the value of symbolism? And we tend to give it a short shrift and say, oh, those traditionalists, etc. But there is value to symbolism in the law, and also there's a value in terms of public trust in the court system. There's a lot of scholarship showing that one of the reasons that people respect the courts and believe in the courts is that they see the big marble building, they see the people in the robes, etc. And the question is how much you lose if you do away with those aspects. That's the one question. The other one is the value of being physically present in the same vicinity. And in our area and what we discussed in the previous panel, we talked about how the fact that the legislatures go virtual, you lose a lot of what actually happens in parliaments, because a lot of the compromises and a lot of what they do is because they meet in the cafeteria or walk together in the hall and not actually in the plenum hall. And I assume the same is in courts, that, you know, that the fact that people actually meet each other and see each other and talk in the hall, etc., can go a long way in advancing compromises, etc. And if you add to it what we know about how people engage each other when they engage virtually, for example, in Facebook or responses in newspapers, etc., vis-a-vis how they would treat each other when they talk to and meet each other. So isn't there a danger that people would be actually more competitive and more aggressive and less compromising?
In both your, thank you very much. In both your questions, I'll be brief now. In both your questions, you're really talking about the process rather than outcome. And a lot in my book, I question and challenge the intrinsic value of our traditions, and I question and challenge the intrinsic value of the way we do things. I'm not saying traditions aren't significant. I'm not saying the way we do things aren't significant. I'm just questioning whether or not they are of intrinsic or simply consequential importance. And if they are, as I believe, and I've thought a lot about this, and I argue about it in fairly philosophical terms, if they are actually, if the benefits are consequential rather than intrinsic, then we go back to my innovative technology. Can we bring about the consequences we want using different technology? A lot of people, for example, talk about the majesty of the courtroom. I just don't buy it. I'm not saying our courtrooms aren't majestic. I'm just saying I don't think it's of intrinsic value, because I don't think people come to the courts and say, I'd like some majesty, please. People come to the courts, well, why do they? That was your first question. But I don't think it's about, it's an empirical question, but I suspect very people say I'm here for the majesty. I think they're there. I think solemnity is important. But I think we've really got to not confuse, and I've got a whole chapter where I call outcome thinking, how we do things today with the outcomes we can deliver. And also, I would say to you, as a final observation, that a lot of my work is not designing court systems for me and my generation, it's for my children and my grandchildren. And it's not at all clear to me that the marble palaces will be valued in the same way by my 3-year-old granddaughter Rosa than a really wonderful, immediately accessible online service. And so, and finally, even if you're right, and that system is a bit better, the traditional system, we're in this very difficult position of providing a Rolls-Royce service for a handful of people and everyone else is walking. And what I want to say is actually it might be better. This is a kind of fallback argument. Even if it is better, I think we can deliver something that's good enough. Interesting question, when is good enough good enough? But I think we can deliver something good enough that'll be far more widely available. So this is where we've got distributive justice, which is my passion, being pulled by procedural justice. But I would argue that it's we can maintain procedural justice in a different form. Great questions, all great questions, but all good things, as they say, need to come to an end. So it's been such a pleasure being with you. Thank you very much.
So thank you again, Professor Richard Saskind, for a really wonderful talk. I think you've poked a lot of people's minds and presented some innovative ideas that we can all take home and think about. And I do hope that next time we can do this in person and host you properly at Bar-Ilan University. So thank you again for taking the time and presenting to us.
Thanks very much. A real pleasure.
And I apologize to the many other people who've raised questions that we could not address in the short time that we've had, but I invite you all to join us in our next meeting. At this point, I want to thank, as this is the concluding event of our conference, I want to thank my co-organizer, Professor Oren Perez and Dr. Itai Bar-Simantov, our BIU LawData Lab manager, who really pulled the things in the back, Dr. Karen Yelin Moore, our events coordinator, Ms. Aviva Fish, and our co-fellow collaborators in the Jean Monnet Center on Digital Governance. We do look forward to welcoming you in our next event, which will be hosted by the Erasmus University in Rotterdam, titled Ethical AI, Perspectives on Law, Regulation, and Policy. You can see the invitation on the screen. So thank you all again for joining us. We wish you a good evening, good morning, good afternoon, wherever you are in the world. And we hope to see you in our next event.